The Senate Judiciary Committee will come to order. We have a first series of bills. Let's go first call the roll.
Mr. Chair,
Yeah.
we've got a number of
Secretary
bills
Deeds.
that are identical to Senate bills that have already passed. I think they passed unanimously, so I'd move the following bills be reported in a block. House Bill 17, House Bill 283, House Bill 738, House Bill 748, House Bill 1318, and House Bill, I'm sorry,
And
House Bill 1320.
House Bill 719.
House Bill 17, 283, 738, 748, 1318, and 1320.
Well, also
719 is identical but needs a technical amendment.
Okay, all right.
That's going to be the next motion.
All right, let's make sure everybody
They were all
understands.
unanimous from the committee.
House Bill 17, Senator Delegate Fowler's bill. House Bill 283, Delegate Brewer's bill. House Bill 738, Delegate Bell's bill. House Bill 748, Delegate Bell's bill. And House Bill 1318, Delegate Adams' bill. And then House Bill 1320, Delegate Adams.
Mr. Chair, the Senate cognates of these bills all passed out of this committee unanimously and passed the Senate
Right,
unanimously.
Again, House Bill 1320, Delegate Adams' bill. Does anybody feel compelled to say anything? Okay. Motion been made and seconded to report the bills in a block. All in favor, vote aye.
Ayes 9, no 0.
Okay.
Okay, Mr. Chair, on House Bill 719, there's a technical amendment. I'd ask Charles to report that.
Mr. Chair, the technical amendment is on line 24 after physical insert evidence. Evidence got left out for the physical evidence recovery kit.
And with that amendment, this bill is identical to Senator McClellan's bill. The amendment's been moved and seconded.
Okay. This is House Bill 719, Delegate Philicorn. First of all in favor of the amendment, vote aye. Aye. All opposed, no. Motion carries.
Mr. Chair, now this bill is identical in form to Senator McClellan's 658 to pass this committee unanimously and pass the Senate unanimously.
Mr. Chairman, I move that the bill be reported.
Second.
All in favor of the motion, vote aye. All opposed, no.
Ayes 9, no 0.
Now we move on to House bills with Senator cognates, except they're contested. The first is House Bill 16, Delegate Fowler's bill, abuse and neglect of a child, safe haven defense. This is similar to Delegate Ruff's bill. She's not here. Okay. All right. Move on then to Delegate Adams. Is Delegate Adams here?
Delegate Adams is not here.
Okay. Delegate Wilt, House Bill 827.
Well, I think that bill's to go by for the day.
Okay. All right.
House Bill 827 goes by for the day.
All right. Without objection, House Bill 827, Delegate Wilt's bill goes by for the day.
Mr. Chair,
Yeah.
with regard to House Bill 756, I understand the clerks communicated to Delegate Adams that he didn't need to be here because it's identical to Senate Bill 614, which reported out of this committee 10-5.
Okay, it's now House Bill 756, Delegate Adams. It has a bail for a person accused of a crime that is an act of violence, notice to attorney for the Commonwealth. It passed the Senate, the committee 10-5 and the Senate 38-2. Does anybody want to speak on the bill one way or the other? Yeah, been moved and seconded. Go ahead.
Does everybody have notice of the people who voted against the bill?
I can tell you who voted for it: Edwards, Saslaw, Normand, Lucas, Obenshain, McDougall, Stewart, Stanley, Deeds, Peake. Who voted no on the bill in the committee is Peterson, Shervill, McClellan, Boysko, and Morrissey.
I'd move to report the bill. All this does is requires notice to the Commonwealth Attorney when somebody who's charged with a crime of violence gets out on bail, or they're granted bail.
Not everybody's here, so
It's been moved and seconded.
All right, it's been moved and seconded that House Bill 756 pass. All in favor of the motion, vote aye. All opposed, no.
Servo, you're out there by yourself, huh?
Ayes 9, noes 1.
Okay. Can we? All right,
Mr. Chairman,
yes, Kristen.
I think we can go back to Delegate Fowler's bill, House Bill 16. Delegate Fowler is here. This one is similar to Senate Bill 63, Senator Ruff's bill. Senator Ruff's bill had some additional provisions that Delegate Fowler's bill doesn't have about the use of newborn safety devices. So we could conform Delegate Fowler's bill to Senator Ruff's bill with a substitute.
Mr. Chair, I move we
desired.
conform the bill to Senator Ruff's bill.
Is there a second? Is there Senator Shriver seconds the motion? All in favor of the motion to conform the bill, say aye. Aye. All opposed, no. Delegate Fowler, do you have anything you want to say?
Move to report the bill.
Okay. Motion's been made to report the substitute to Senate Bill 16. All in favor of the motion, vote aye. All opposed, no.
Thank you, Mr. Chairman.
Thank you, Delegate Fowler.
Ayes 11, no 0.
Senator Wilkes, our Delegate Wilkes bill goes back to Jay.
Yeah. Okay.
Delegate Campbell's bill now.
Is Delegate Campbell here? Okay. All right, we have then Delegate Campbell, which is House Bill 265. And this has to do with multi-jurisdictional grand jury, elder abuse crimes. Delegate Campbell, welcome.
Thank you. Thank you, Mr. Chairman. The bill allows for a multi-jurisdiction grand jury to investigate instances of financial exploitation of people who are mentally incapacitated and instances of neglect and abuse of people who are mentally incapacitated. The bill is supported by the Virginia Academy of Elder Law Attorneys, the Virginia Bankers, and the Attorney General's Office.
Mr. Chair.
Yeah. Senator Dees.
Delegate Campbell, this committee's held the line pretty good the last few years on expansion of multi-jurisdictional grand juries. Tell me why the Commonwealth Attorney of Rockbridge County, for example, can't handle these situations when they arise in Rockbridge County.
Well, I can tell you best from going back to the bankers than the people who see our elders being taken advantage of it with their finances. We have a lot of that goes on in every community in this state, people that are entrusted to take care of your money and manage your affairs can't keep their fingers out of your money. So it would really be great to have the process set up so that you could have multi-jurisdictional because it has to be prosecuted where it occurs.
Mr. Chair,
Senator Dees.
are there examples of cases that have arisen in our part of the world where a multi-jurisdictional grand jury would have come in handy?
I'm sorry, I didn't.
Are there examples of cases that have arisen, say, in Rockbridge or Augusta or Nelson or Bath or Allegheny or Highland or Botetourt where a multi-jurisdictional grand jury would have come in handy?
Well, the Commonwealth Attorney could also use it to set up a multi-jurisdictional grand jury. If he had someone who lived in Rockbridge that was doing it, but they actually was doing it to someone in Augusta County.
Mr. Chair.
Senator.
And this is sort of
Senator Peterson.
This is sort of variation on the same question. Is there any reason why a grand jury, for example, in Rockbridge or Augusta couldn't handle this? I mean, I tend to think of elder abuse as being typically a crime that's targeted at one person, not something that spans county lines. And we have been very reticent about expanding this statute because it is the ultimate Christmas tree. It started out as a Charlie Brown Christmas tree, and then it became like the Rockefeller Center Christmas tree.
A lot of low-hanging fruit there.
Oh.
I understand where you're coming from.
Any further questions? Senator Morrissey.
Good afternoon, Delegate. 33 years ago, when I was Commonwealth Attorney in Richmond, we had, I think at that time, a multi-jurisdictional grand jury that involved itself in almost primarily, and I could be wrong, Mr. Benjamin will correct me if I'm wrong, drugs. And that's because the distribution of drugs and the conspiracy to distribute same expanded beyond the city of Richmond or Henrico or Hanover, Chesterfield. It made sense. We have similar things for cigarettes. But similar to the question that Senator Peterson asked, when I think of exploiting adults, which I think there's a special place in purgatory for somebody that does that, I don't think of it stretching over jurisdictional lines. So if you could specifically answer that, why add this ornament to the ever-growing tree?
Well, I can appreciate your question, and I'm trying to think of a particular instance right now, but the dealing with our seniors, you can have people that are entrusted in the community to deal with, and they actually sometimes can get assigned to deal with the seniors and take care of and manage their assets. And sometimes these people can also be across county lines. Like in my case, they could be in Lexington instead of Rockbridge. So, well, let me back up. Buena Vista instead of Rockbridge. Lexington and Rockbridge share everything. They could be just across the line, and they could be doing it to people over there also. So this would give us the opportunity to investigate these people and give them a proper place in purgatory.
Final question, Mr. Chairman.
Senator Mercy.
Similarly, Delegate, and I appreciate you bringing the bill, but you could also, and I say this respectfully, pick up the phone and tell your counterpart in the contiguous jurisdiction, hey, this guy that just bilked Mrs. Smith out of 50 grand, we have reason to believe she bilked one of your citizens in your jurisdiction, right?
You could easily do that, but I'm prior law enforcement, and I can tell you that not all Commonwealth attorneys will do what they should do. In other words, you can call him and tell him, and that'll be the end of it.
Okay, Senator. Yes, Senator Peake, you had a question?
Yes, for Mr. Chairman, for the delegate. Is there a particular incident, or is any particular jurisdiction feel like they need this?
This actually came from the Attorney General's office.
From the attorney, okay, so he has requested this. Thank you.
Yes.
Okay. And, we have a speaker. Would you like to, somebody else want to speak? Your name?
Hi, I'm Vic Nichols, and I would like to speak for this bill.
Okay, thank you.
My great-grandmother, when she was incapacitated, her daughter, my grandmother, took care of her. It was enough to do that. They didn't live in the same city that we did. So the people that actually would go out there and try to get something done on an issue like this, they're in another city. There could be several cities over. This might actually help us because it was just enough for my grandmother, obviously, to take care of her mother. Trying to get everything else done and coordinate all that, that was left to the grandkids. Okay. So if you could, find it in your hearts to help people like our family out, that would be appreciated. Thank you.
All right, any questions? Anybody else want to speak?
For those attendees in the Zoom room who would like to speak in favor of the bill, please raise your hand electronically now. Mr. Chairman, we do have one person with their hand raised.
All right.
Raymond Fatihi, would you please unmute and begin your testimony?
Yes, good afternoon, everybody. First of all, thank you to the committee for the hard work that you all did before crossover. Lots of heavy lifting, much appreciated. Second, I am here in favor of the bill on behalf of Norfolk, Albemarle County, Henrico, Loudoun, and Prince William County Commonwealth's attorneys. Stepping outside of that and speaking for myself for a moment, we are long overdue to have a wider look at reforming the grand jury system in Virginia and adopting the powers of the multi for our regular grand juries to allow for investigative grand jury work. In the meantime, this is a good idea. This does not expand the power of the Attorney General's office to take these cases. Otherwise, we would oppose. It It simply allows a multi-jurisdictional grand jury to issue subpoenas to investigate this work, to bring in witnesses, to have the witnesses testify under oath under penalty of perjury. There is a benefit. And these are charges that can only be initiated on the okay of the Commonwealth's attorney, as I understand it. So this deals with vulnerable individuals, with elder abuse, with venue problems, with people who may invoke their right to counsel. And where a cover-up is not a difficult thing to do. It's simply another tool in the toolbox to allow us to vindicate the rights of vulnerable victims. So the policy can sometimes make strange bedfellows, but this is a bill that we believe someday we need to dispense with the Christmas tree. But in the meantime, this is a bill that has a legitimate purpose that we feel is appropriate.
Anybody have any questions of the witness? Yes, Senator Morsi.
Ramin, let me ask you a question.
Sir.
Give me a concrete example of a situation involving elder fraud, financial exploitation, where you say that it happened in Newport News. They couldn't pick up the phone and call you. Give me an example of why we need multi-jurisdictional grand jury to handle financial exploitation, a real-life example.
I can't give you a real life example. I can give you what I think in the real world could easily happen. I think that the biggest trouble here is the difference between search warrants and subpoenas. Some of the records that we would need, for example, if it's an abuse of a power of attorney situation, or if it is an exploitation under a financial exploitation that involves bank records. So those records we could get under, in some instances, under a subpoena pursuant to 19.2-10.1, under other situations by search warrant. There are sealing provisions and sealing limitations for those requests. And this is a situation where if we're investigating this situation, there may be a legitimate defense that means that no charges should be brought. The confidentiality of the grand jury allows us to conduct an investigation, get to the bottom of it without risking the reputation of somebody who may have not committed a crime. That's I think the main value to it. You're absolutely right. Any Commonwealth's attorney who cares about his citizens is going to take the call from Delegate Adams or from you, Senator, or from anybody else, and if the venue lies in that jurisdiction, it's going to indict it. It's really the upstream part of it that I would argue has some merit. It's if the committee has reservations about the bill, this is not a make or break, but it is a legitimate tool that we saw as relatively uncontroversial.
Okay. Any further questions? Is there a motion? Motion to report.
Mr. Chairman.
It's been moved and seconded to report the bill.
Mr.
Yes,
Chairman,
Senator
so I have a substitute motion to PBI. Speaking to that motion.
It's been moved and seconded to pass the bill by indefinitely.
And speaking to that motion.
Yes, Senator Sherrill.
Thank you, Mr. Chairman. I just want really say, we've seen like 3 or 4 bills in the last couple sessions to expand these multi-district grand juries. This committee's taken a pretty hard line against doing that, and Delegate Campbell, it's no ill will towards your specific bill or you. It's just we don't like expanding the multi-district grand juries in this committee. We've been fighting that, so that's where this is coming from.
Okay. Is there any further discussion? All in favor of the motion to pass the bill by indefinitely, vote aye. All opposed, no.
Ayes 9, noes 3.
9-3. Yeah, thank you, Delegate Campbell. Appreciate it very much. Delegate Simon, Virginia State Police Communication System. This is a recommendation of the Distinguished Virginia Code Commission. Isn't that right, Delegate Simon?
That is absolutely correct, Senator. This is a recommendation of the Code Commission. I think you could have carried it just as easily as I did. I got lucky and got this one. This one just cleans up language about a basic communication system and teletypes that the police are required to maintain around the Commonwealth. They don't have the teletypes anymore. That question came up, well, shouldn't we need it if the grid goes down? They don't have it. This is literally just obsolete language that doesn't apply anymore.
You mean you can't use teletypes anymore?
So, Mr. Chair, this step makes no substantive change in the law.
No, it just cleans up the code, Mr. Speaker.
What about telegrams? Yeah, okay. Been moved and seconded that the bill be reported. All in favor? Yeah, Senator Morsi, you say something?
I just want to say I think Delegate Simon has done something that we all wish others would do. every time you introduce a bill, think of a bill that you can introduce that will take language out or clean up the code. He does that here. Congratulations, kudos to doing it.
Thank you, Senator Morrison.
This is the Code Commission. One of the tasks of the Code Commission
There's always a motive,
is
gentlemen.
to clean up the language in the code. I've been moved and seconded that Senate Bill 342 to get rid of the word teletype. All in favor of the motion, say aye. Vote aye.
All right, I got Stanley
Ayes
and
13,
McDougal
no
vote for
zero.
me in this room. That never happens. So.
13-0. All right, thank you, Delegate Simon. Delegate Sullivan, Uniform Fiduciaries Income and Principles Act to replace the prior Uniform Act.
Thank you, Mr. Chair, members of the committee. This bill takes a lot of language out of the code, Senator Morrissey, but it replaces it. This bill is a recommendation of the Wills, Trust, and Estates section of the VBA. Also, of course, you all know how well bills out of the Uniform Law Commission are vetted before they are circulated. This was adopted by the Commission in 2018. Virginia adopted the existing Uniform Principal and Income Act 23 years ago in 1999. What this would do is replace it, update it. It reflects more modern trust investment practices in how we allocate principal and income. The goal is to better carry out the intentions of the decedent or the trust creator and to govern the proper distribution of assets to beneficiaries and heirs and devotees. It recognizes the current trend towards something that I don't really know much about, but others here do, called total return investing, and it does include something called a unitrust conversion rule to allow older trusts to take advantage of modern investment trends. This will sort of bring further clarity to people practicing.
Mr. Chair, does anybody oppose this bill?
Not that I know of, Mr. Senator.
Okay.
Senator.
Second.
Any questions? Okay, all in favor of the motion to report and it's the bill which has been seconded, all in favor of that motion, vote aye. All opposed, no. Thank you for your eloquent presentation.
Thank you, Mr. Chairman. I know you were all riveted by
Yeah,
it.
it was exciting. Thank you very much.
Ayes 14, no zero.
The bill passes. Senate Bill 409, Delegate Ballard. Recommendation of the Boyd Graves Conference. Okay, Delegate Ballard.
Thank you, Mr. Chairman, members of the committee. As the senator stated, this bill was brought to me by the Boyd Graves Conference and has the support of the Virginia Bar Association. The Boyd Graves Conference basically undertook a review of Virginia Code 8.01-232 because the statute as written caused a little bit of confusion for some practitioners. So as to Senator Morrissey's point, this bill clarifies some of the requirements in that code section, which is a written promise not to plead the statute of limitations. I don't know of any opposition to this bill, so in an effort to speed the process along, I'm happy to yield to any questions, but it's a pretty straightforward bill. It just cleans up the code for us.
Any questions of Delegate Ballard?
Mr. Chairman.
Moved, yeah, and
Mr. Chairman, I have a question.
Yeah, Senator Servo has a question.
Can you explain what the confusion is that's in the current statute?
So go ahead, I'll yield to
Jeff.
Mr. Chairman, members of the committee, Art Schmaltz from Hutton, who chaired the Boyd Graves Conference Committee on this topic, is on the line. If we could hear from him directly, that might be more helpful.
Who's online?
Art Schmaltz.
Art Schmaltz.
Mr. Chair, Arthur Schmaltz is online. Arthur Schmaltz, could you please unmute?
Arthur Schmaltz.
Yes, I should be. Am I unmuted?
Yeah, go ahead.
Thank you very much. To address the question of Mr. Servo, the confusion relates to at least two of the three conditions that are laid out in the statute, the current statute, for recognizing a promise not to plead the statute, or what is more commonly known among litigants as a tolling agreement. Specifically, there was a case that a Supreme Court of Virginia case about 2.5 years ago called Radiance Capital that invalidated a promise not to plead the statute for not complying with all three of those conditions. And it's really the two number 2 and 3, the conditions that are problematic. The second one is in order to be valid, a promise not to plead the statute has to be not made contemporaneously with any other agreement. And then number three, it can't be made any longer than the original limitations period. And so what happens is if you get like many cases for litigants who've done tolling agreements where you don't specify a specific period of tolling, you just agree, for example, as is often the parties agree to toll the limitations period to allow for settlement discussions. And if at any time either party can terminate the tolling upon written notice, well, under the ratings capital section, that would be invalid.
Mr. Chair, I like Art a lot, but I think he's made his point.
I think he's made.
Mr. Chairman, I have another question.
Scott.
Let's hear him complete. If you said what you want to say?
I have a question unrelated to what he just was talking about.
Let's finish them. If the gentleman would like to say anything further, we appreciate him speaking to us. Okay, is there Senator Shervill?
Mr. Chairman, my question is how this statute would relate to existing tolling agreements and whether or not we need to do something about the potential retroactivity of this.
Mr. Ballard or Jeff, who would like to answer that question?
Mr. Chairman, to the Senator's question, I would probably defer to the gentleman online for that. That is a good question, how it would apply retroactivity, the retroactivity of it. So if he knows the answer, I'd certainly yield to him speaking to that.
Yeah, Jeff, can you answer the question? How about Mr. Schmaltz online?
Art's best to answer.
Thank you very much. Yes, I can. There should be nothing in here that would retroactively impair any tolling agreements. The question, I think, may be more properly addressed to whether or not the legislation would apply retroactively to save or salvage a tolling agreement that doesn't comply. And that's something I would very much be in favor of. And I don't know the answer to whether this would be some sort of, I'm sorry.
Yeah, Senator Peterson.
I think the answer would be this could be made retroactive to all existing agreements. I like this change. This statute as it's written right now is very unfriendly to claimants. And so I would be happy to make it retroactive. I get a second to that motion.
Well, Mr. Chairman, we wouldn't want to make it retroactive. We would just want it to go into effect July 1 for all agreements. And
but what about agreements entered before July 1?
I don't think you want to.
I don't think constitutionally you can make it retroactive. You would just have it go into effect July 1.
All right. Senator Deeds.
Mr. Chairman.
Moves. Senator Shervill.
I think what it needs to say, though, is that this applies to any contract entered on or after July 1, so that we don't have some fight in court about whether it's retroactive or not in the future and avoid another Supreme Court appeal or Court of Appeals appeal, whatever. So
I'll move that amendment.
All right, Christian, you got that? She got it.
Second.
It's been seconded. All in favor of the motion to make it prospective beginning July 1, 2022. All in favor of that amendment, say aye. Aye. All opposed, no. The amendment is, passes. Okay, anything else? Is there a motion to been moved and seconded the bill as amended be reported? This is Senate Bill, House Bill 409 of Delegate Ballard. All in favor of the motion to report the bill, vote aye.
Ayes 14, no 0.
Okay, all right, thank you.
Thank you, Mr. Chairman, members of the committee.
Preparing. House Bill 449, Delegate Bulba. There he is. Distrained or levied on personal property, auctioneers.
All right, very good. Thank you, Mr. Chair and members of the committee. The language that's actually in this bill was adopted as part of last year's budget and is also in this year's introduced budget. And so this is really meant to fix an ongoing problem, and so it makes sense to go ahead and put it into the code here. And so this really just deals with how or when you go ahead and put to auction something that's been distrained upon by a treasurer or a sheriff. Read very literally, this section of the code requires that if you go ahead and put something up for auction, that it cannot leave the locality in which it was distrained upon. And that is very limiting in terms of what kind of auction houses. And so what you wind up with is underbids or even no bids at all. That clearly isn't good for the locality because you're not maximizing how much you're getting back. It's also bad for the person whose property it is because any surplus ultimately goes back.
Did anybody oppose this legislation? legislation in the House?
No, sir. This was brought by the
Okay.
Treasurers Association, not aware of any opposition.
Any questions? Okay. All in favor of the motion to report House Bill 449 of Delegate Bulva, all in favor, vote aye. All opposed, vote no.
Ayes 14, no zero.
Okay.
Thank you kindly.
Thank you very much, Delegate Bulva. And now we have Delegate Hope. It's House Bill 671, Hope Card Program. Is
Mr.
this
Chair, if
named
this
after
bill's
you?
reported, it needs to go to the Finance Committee.
Okay, right. Yeah, Delegate Hope, so you're talking about the Hope Card Program. Is that named after you?
Pure coincidence, Mr. Chairman.
So
I
what's
promise
a
you, this-
Hope Card?
This is a bill you reported out 2 years ago. Senator Vogel carried it and failed in the House, finally got it through the House this time. I had to do a lot of begging on our end. This would direct the Office of the Supreme Court to provide a card to anyone with a protective order as a discreet way that they can ask for help. Usually if you want to bring around your protective order, it's a 2-page document that you have to carry with you. But this is a laminated card that fits on a size of a credit card that people can use. You use it for law enforcement, a coach, a teacher at school, just so they can make sure that they know the subject of the order. And that's the bill before you. Some jurisdictions are doing this. I know Fairfax County is one that's doing it. There may be a couple others, but the cost that's involved in here, I think it's about $91,000, would require this throughout the state.
I'll move the report.
First, any questions of the patron? No questions. Senator Morsi.
Good afternoon, Delegate. Quick question, is the Hope Card named after the patron or the emotion?
It is pure coincidence.
Okay.
Senator, but thank you for that.
Okay.
No royalties that I'm aware of.
Is there, yes, Senator Peake?
Yes, Mr. Chairman, I do have a couple concerns. The subject of the protective order has to get this card and carry it around. Is that the purpose of this bill?
Not the subject, the victim in this case.
It's the victim?
Yes.
Okay. 'Cause
That's right.
That's,
Okay. That's why it's called a Hope Card, because
When I
a
read,
potential victim of a
well, who has
protective
been
order.
issued a permanent protective order,
Person who's been issued one, that's correct.
not the person that's issued against. Issued on their behalf. Issued on their behalf. That's the part that I thought was issued against, issued on their behalf. That's what I needed to know. Thank you, Mr. Chairman.
Yes, sir, Mr. Chairman.
Any other questions?
Mr. Chairman.
Yeah, Senator
I just-
McDougal?
I guess most protective orders are pretty straightforward. They check the boxes, but some of them are more prescriptive in language and can be a little lengthier. If I'm reading this correctly, then all the terms have to be on there. What if the terms are greater than the size of your card?
Well, I don't know if anyone here knows
So I just,
if that works.
Okay. Yeah, state your name.
Mr. Chairman, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. I know we have the Supreme Court folks in the room here, so they can correct me if I'm wrong here, but it's the most basic pertinent information that's drafted onto the card. It's not up to the petitioner to choose that. Usually, the Supreme Court works with figuring out how to fit the criteria onto the fields in the card.
I guess, Mr. Chairman,
Yeah, Senator
maybe it happens
McDougal.
different in different jurisdictions, but sometimes judges will write in terms of the protective order about where they could be if it's more prescriptive, particularly if there's children involved. What if those terms are lengthier than what could be written on the card? And so what?
That may be a question for the Supreme Court folks. I know Jamie Clemmer in the Supreme Court does that. That has not been an issue that's come up in the past. The Supreme Court issues about thousands of these every single year.
The Executive Secretary of the Supreme Court is here to speak. The Office of the Executive Secretary of the Supreme Court, yeah.
Eileen Longenecker with OES at the Supreme Court. The bill does say to the extent possible. So clearly, you can't include all the information on a protective order on the credit card size card.
Okay. Any further questions? Senator Morsi.
What this card does is this. People get issued protective orders, not just for domestic violence, but here's a situation it's going to cover. When that, I'm going to say woman and husband, but it can go either way. When that battered woman gets a gets a protective order against the abuser, and they come in contact with one another, the police are called, you pull the card out there, it makes it so much easier for the LEO to address the situation. I think it's a Great idea, Delegate Hope. I congratulate you on coming up with this. Wonderful.
Okay. Any further discussion? Is there a motion? The motion is to report and refer to finance, and it's been seconded, the Senate Bill 671 of Delegate Holtz. All in favor of the motion to report and re-refer to finance, House Bill 671. Vote aye. All opposed, vote no.
Ayes 14, no zero.
Okay, now Delegate Hope, you got another one, Boyd Graves Conference Bill, right?
Yes, sir.
Explain that one.
All right.
Person under disability.
House Bill 678, again, this is the Boyd Graves Conference recommendation, support of the Bar Association, requires the appointment of a guardian ad litem for defendants named by the general description of parties unknown in suits involving real property. You see the line, line 33 reflected there. Persons unknown are individuals who are unknown identity at the time of the initiated and may still hold interest in real property they are identified. Allowing for the appointment of a guardian ad litem in these cases to these parties unknown ensures that their interest in real property will not be disregarded just because of their absence.
And Mr. Chair,
Senator
Delegate Hope,
Davies.
when I looked at this bill, the only thing I thought was that any lawyer worth of salt who filed one of these suits was going to have a guardian ad litem appointed for parties unknown, because you never know if one of those parties is an infant or under a disability. So this is good practice already.
Yeah, right.
Whoa.
Okay, Senator Peterson.
Okay, let's slow down the train here a bit, folks.
He wants to slow down.
Okay. Typically, we have a guardian ad litem for a child or someone who's incarcerated, but it's always somebody under a disability. This is the first time I've ever seen it used for somebody unknown, i.e. a John Doe or a Jane Doe. I'm not saying it's a good or bad idea, just this is an expansion of GALs.
Mr. Chair, but the
Senator
problem
Deeds.
is that a party unknown may be a person under a disability.
Well, I've never seen it done for a partition suit like
I
that.
think you do. Well, at least
Okay,
in
all
my.
right, we got the Boyd Graves
All right.
Conference in the form of.
Who is
Jeff
Boyd
Palmore.
Graves, by the way?
Yeah, Money Board.
There might be someone online if you want to
Money
have a
Boyd is
specific
a
question,
professor at
Mr. Chairman.
UVA, whom I knew quite well. Money Boyd. He ran for Attorney General one time in the 60s.
Okay.
He was blind as well. Money Boyd was a distinguished professor at UVA Law School when I was there. Jeff, would you like to say something?
Well, we do have someone online that if you have specific questions.
Right, just to say, Steve Price from the Boyd Graves Conference, who chaired this committee, is
Okay.
online to answer
Steve-
any questions.
Distinguished Steve Price from Leesburg, right?
Well,
Steve, you there?
Mr. Chair, Stephen Price is online. He should be joining in a moment. Stephen Price, would you please unmute? Stephen Price, would you please unmute?
Senator Woods, can you all hear me?
Yeah, Steve? Yeah, welcome.
Well, thank you. I appreciate the opportunity. The point was made that frequently parties unknown can be persons under a disability in the sense that they could be incarcerated, or more likely they're minors, or they could be suffering from some other type of mental disability. And so this was designed to add the description of parties unknown to the list of persons under a disability. Also, part of the concern is the Boyd Graves has been studying in recent years, noticed by publication, and the problems presented by the decline in the printed press. In the old days, well, still, when you have this type of case, there's an order of publication, which is published in what's called a newspaper of general circulation, with the idea that folks out there may see it and can identify it. You don't, in these types of cases, just put parties unknown. What the typical situation is that their property was owned, and there was not by someone. There was not a will. There was a list of heirs, and among the heirs was Uncle John, who 30 years ago moved to New York, and nobody's had any contact with Uncle John since then. They don't know whether he's alive or dead. If he's dead, did he die with a will, or would his interest in the property descend to his children, surviving spouse? So what you do in these orders of publication is that you describe Uncle John, if living, if not living, then his surviving spouse, heirs, successors in interest who are joined as parties here to the case as quote unquote parties unknown. Like I said, in the old days, and this is the additional reason, people read the newspaper, they would read the legal ads, and they'd say, oh, yeah, I saw Uncle John last year. He's not in New York. He moved to Florida. I know where he is. And the word would get passed on that, hey, actions being taken in the Circuit Court of Loudoun County or wherever with respect to property that you inherited an interest in. But now with the decline, it's even less likely that that's going to get to them. We don't know what the answer is yet. We're struggling to make suggestions. But anyway, that's the additional reason why Boyd Graves is suggesting this. And as Senator Deeds pointed out, practitioners, we think good practitioners are already doing this, but we're not sure that everyone is. And it's something that should be done in our view, and therefore we want to add it to the statute.
Okay, thank you very much. Senator Peterson has a question.
Well, first of all, I'm not a good practitioner, and I never do this, so there's one thing. What if you have a situation where perhaps there's a foreclosure or there's an issue as to, for example, title? I think that's where it's most likely going to happen is in title. Someone ends up with a deed, and you can't put the title together, or let's say they have a note on the property and they can't show how they got the note, but they're holding the note. So in that case, you may be adding a guardian ad litem to protect a creditor. That's a little bit different than what we've historically done. I'm not saying this is a bad idea. I actually think it might be a good idea. I'm just saying, recognize that we're no longer taking somebody under disability. Oftentimes, we're taking somebody who has an interest in property or is a creditor to that property and putting a GAL on them. And again, GAL's picked up by the taxpayers, not picked up by the person in interest. Just something to think about, folks.
Well, actually, what the statute says is that they're supposed to be paid out of the estate of whatever share they might have coming to us. Typically, in these cases, partition action, or it's a suit to enforce the lien of judgment.
All right, Steve, I'd give up.
Thank you, Steve.
Yeah.
Move to report the bill.
I think
Well done,
Mr.
Mr. Price.
Peterson just gave up, which is a good thing. Okay, so the motion to report the bill by Senator Deeds and second by Senator Stewart. All in favor of the motion, vote aye. All opposed, vote no.
Sasslaw was open next. Okay.
Ayes 13, no 0, 1 abstention.
Thank you, Delegate Hope.
Thank you, Mr. Chairman.
Hope of Hope Card. Okay, House Bill 782, Patron Delegate Williams. Okay, yeah, Wynn Williams, welcome.
Hello,
This is
good afternoon.
non-suit. This is a recommendation of Boyd Graves. Did you ever know Money Boyd?
What was that?
Money Boyd of Boyd Graves.
No, I did not know him,
Okay,
sir.
I knew him well. Anyway, go ahead. This has to do with appeals, non-suits appeals from the General District Court.
Yeah, so really the basic issue was that if somebody wanted to take a non-suit, a plaintiff wanted to take a non-suit from their general district court and they got up into circuit court, current law requires that they go all the way to trial. And nobody likes that, just to get a non-suit. So this bill would correct that issue, allow a plaintiff to take a non-suit in circuit court.
Mr. Chairman.
Simplifies the process. Yes, Senator Sherrill.
Thanks. This basically is an attempt to clarify the law after a Fairfax County Circuit Court opinion, right?
Yes.
Right, and that, Mr. Chairman, further question?
Yeah, Senator Sherrill.
Thanks, and is that case on appeal to the Supreme Court, or are you aware of any, appellate authority or anything that holds the same thing, or is this a problem in, just our circuit in Fairfax?
Jeff Palmore.
Yeah, okay, I see him nodding his head, okay.
Okay, any discussion?
Mr. Chairman.
Is there, Senator Peake.
Question, Senator Servell. So Senator Servell, did that Fairfax judge mess up the whole thing for the state?
No, just his courtroom.
Just his court. Okay, thank you.
Okay, is there a motion? Motion has been made and seconded to report.
Mr. Chairman.
782, yes, Senator Sherrill.
I'm sorry if I got a retroactive kick today, but from my point of view, this is procedural. And I guess we don't need a retroactivity clause because it would. Yeah, I see counsel shaking his head. Okay, we're good.
Procedural, you do not have to.
We're good.
Procedural goes prospective only. Okay.
Well, then maybe we should make it retroactive. So.
All in favor of the motion to adopt Senate Bill
Excuse me, Mr. Chair.
782.
Mr. Chair?
Yeah.
Before the
Senator-
train goes too
Senator
far down the
Morrissey.
track.
Senator Morrissey, you have a question?
Thank you. And furtherance of what Senator Serville said, we had the same issue before with the matter that came up regarding if something is procedural, okay, we're going to give it retroactive effect, and if it's not, we are going to give it if it involves punishment, prospective effect only. Is that something that, and we needed to correct that, is that something that we want to address right now, Senator Servo, and not have varying circuit court decisions on this?
But only effective July 1. So, Mr. Chairman?
Yeah, Senator, who's this, Sherrill? Who asked the question?
Servo.
Sherrill.
And I agree it's clearly procedural, and so it's clearly retroactive, but it also wouldn't affect any cases until July the 1st.
Right.
And so if we added an emergency clause to it and a retroactivity provision, it would nuke any appeals that are out there on this issue, if to the extent anybody took any. And so I think that's...
Is that necessary?
Yes, it is necessary.
It has bipartisan support, almost unanimous.
Let me
Mr.
ask
Chairman,
anybody, Senator Jeff Paramore, anybody, is this require an emergency clause? Is it that much of a problem?
Mr. Chairman, members of the committee, I can't speak to the retroactivity provision, but if we want to solve the issue faster than July 1, then an emergency clause would help resolve that if there are cases that have been appealed and...
Mr. Chair, has this been a problem in more than one court in Fairfax County?
I believe, well, and Miles Dunville is on the line if there are questions, but I believe there have been several cases in Fairfax where this has been an issue, and I think it's the judge interpreting the law accurately.
This Miles, is he online? Would you like to say something, Miles?
Yes, thank you very much, Mr. Chair. I appreciate the opportunity. The study committee checked, and as of the time that we recommended this to the Boyd Graves Conference, we could not determine that anyone other than this one judge in this one case had taken this position. Obviously, it needs to be corrected because no one should have to wait till trial to take a non-suit. If you waste time, people showing up or preparing for a trial is not going to happen. So all this does is conform the practice for the appeals. And if you want to put an emergency clause, you can, but as I say, I'm not aware that there's been any repetition of this outside that one courtroom.
Okay, all right, is there a motion?
I move the emergency clause.
Why?
Because I have to practice in this circuit, for God's sakes.
I've been motioned to adopt an unnecessary emergency clause. All in favor of the motion say aye. Aye. All opposed, no? No. Okay.
Scott likes the emergency clause.
Scott likes the emergency clause. The king gets vote otherwise. Okay. All in favor of the motion to adopt the bill, Senate Bill, House Bill 782, say, vote aye. All opposed, no.
Ayes 14, no zero.
Thank you.
14 to no, 0. Thank you very much, Delegate Williams. HB 887, Delegate Tata, welcome to our committee.
Thank you so much, Mr. Chairman. So I'm introducing HB 887 on behalf of a retirement community in Virginia Beach called Atlantic Shores. This property operates as a co-op. The bill provides a technical fix that will help just a handful of these types of properties and will allow the property interest to pass to their heirs. The real property transfer on death statutes allows for someone to transfer real property outside the probate process. A concern has risen specifically for co-ops because it appears that when the real property transfer on death statute was written, the interest of co-ops was not considered. This bill seeks to correct this and make clear that someone who owns a co-op can transfer that through a transfer on death deed. Now, I'm not a lawyer, and you already know Jeff Palmer, so he's here to answer any questions.
Delegate Tata. Go ahead, Senator Dees.
Mr. Chair, I've got no problem with the bill. I just wonder why the language on line 42 is necessary if this is already, you can already do it, and I believe you can. And if you can't already do it, why is this language necessary?
Delegate Jeff Palmore, Doug Palmore.
Mr. Chair, what was the line number you were pointing
At
to?
line 42, the provisions of this act are declarative of existing law.
Yes, Mr. Chair, members of the committee, there are transfer on death deeds for co-ops that are existing right now that we don't want undone by an act of this General Assembly. So we're trying to clarify the law as it stands now, but not undo anything that might already be in place.
Mr. Chair, if this is really declarative of existing law, why is the bill necessary?
Mr. Chairman, we feel that it is clarifying the law. It's a helpful clarification to the law. We don't want to do anything to upset deeds that are currently been recorded. And Allison McKee is on the line if there are questions, and she has worked on these issues.
Senator Stewart has a question too.
And Allison McKee is more experienced in these issues, but it is not technically a deed. It is a proprietary lease and a share that you own. So that's where the rub is, because the transfer on death deed uses the term deed. Technically, if it's a co-op, it's not a deed.
Okay, yeah, Allison McKee, are you online? Allison?
I don't either.
Mr. Chairman, Allison McKee is online. Allison McKee, would you please unmute?
Yes, I should be unmuted now. Can you hear me?
Sure. Yeah, thank you.
Yeah, so just by way of background, we're seeing that some attorneys are out there filing what is the conveyance document for cooperative is not called a deed. It's an assignment of proprietary lease and share of stock. Sometimes it's called an assignment of co-op interest, but it's not a deed per se. By statute in Virginia, the Real Estate Cooperative Act, a cooperative interest is real estate. So our concern is that there are documents out there that are called something other than a deed, called an assignment of a cooperative interest or assignment of a proprietary lease. And if one looks at the statute as currently written, it only refers to a deed per se. So this is designed to clarify that assignments of proprietary leases and or cooperative interest would be permitted under this transfer on death deed statute. So it's an attempt to really clarify title that's out there currently and prospectively make clear that these types of conveyance documents are intended to fall within the purview of the statute.
Mr. Chair, and so the language on line 42, which provides that the provisions are declarative of existing law, that language is either unnecessary or a fiction. Isn't that true? Mr. Chair.
I think you could also argue that this is how it's always been done for those that are doing it, but this is a clarifying bill.
I don't know that we've allowed this sort of language to go in bills that have been passed through this committee before.
Mr. Chair, I would echo Mr. Chair's comments that typically this committee has been reluctant to use that language on line 42.
Well, Mr. Chair, I'd move to amend the bill by striking the language on line 42.
Okay. Is there a motion to adopt the amendment?
So moved.
Second. All in favor of the motion, say aye. Aye. All opposed, no.
Now I'd move to report the bill.
I might say too, in the annotations, they can explain this is existing law.
Yeah.
Okay.
Thank you, Mr. Chairman.
Is there a motion then? Motion's been made and seconded to adopt the bill as amended. All in favor of the motion, vote aye. All opposed, no.
Ayes 12, no 0, 2 abstentions.
Thank you very much, Delegate Taylor.
Thank you.
Is there any other business to come before the body? Okay. We got it out in record time. If no further business, the meeting is adjourned.